It's nice being in Knoxville, actually, know some of the lawyers. All right, counsel.
Good morning. May it please the court. Autumn Bowling, humbly on behalf of the petitioner appellant, Geoffrey Paschel. I'd like to please reserve 4 minutes for rebuttal. Thank you.
All right.
I need to make sure that it is abundantly clear to this court that nothing that has happened in this case that brings us here today is Mr. Paschel's fault. Absolutely nothing. We are here today because although a verification was filed only 6 days later, and the same day the state filed a motion to dismiss, Mr. Paschel's counsel filed an original post-conviction petition without the verification. And this is a problem only because the Maxwell opinion has been interpreted to mean that represented petitioners cannot make any corrections, turning a statute that does not identify a lack of verification as a reason to dismiss, even though there is an explicit list for dismissal. And this turns the Post-Conviction Procedures Act into an absolute minefield for petitioners who secure counsel for their post-conviction petitions. I think we have a very dense set of briefings here today. We have raised a lot of different issues we find with the trial court's decision. I think the one I'd like to focus on primarily is whether Maxwell makes this a jurisdictional issue and that lacking verification at the time of filing causes somehow a jurisdictional issue. And I would submit that it does not. And the Hinton case that we have all cited, and that I believe Judge Montgomery was part of, is further proof of that. In Hinton, the petitioner there was allowed to orally verify his petition, even though back when his original petition was filed, which I believe was through counsel, did not include a verification. And by allowing him to orally verify, and by this court affirming that decision by the trial court, we can see that it must not be a jurisdictional issue. Otherwise, that opinion would not be able to stand.
Wasn't that the case, though, that the state agreed in their response that the petition was fine, and then they didn't raise the lack of verification until right when the hearing's getting ready to start? Is that the one I'm thinking of?
That is that case, Your Honor, and that is the set of facts as I know them. And what I would say to this court is that back in the post-conviction court, when the state filed its motion to dismiss, it does at least concede that we are timely. And that, I think, is very similar to what happened in Mr. Hinton's case, being that the state said initially it met the threshold requirement. And so I believe that that is what makes us similar to Hinton in that regard. And so by not having the verification, we are in a much more similar position to Mr. Hinton than we were to Maxwell, Vaughn, or any other petitioner. The post-conviction court said that it can overlook minor procedural defects, considering we filed a 36-page petition full of factual allegations. And the only thing missing here is the verification by Mr. Paschel. Even though me and Mr. Gaines prepared this petition, we investigated it. It was part of our lead up to all of this. We are continuously. And one of the most, I think what's important for this court to know in the backdrop of this petition, this isn't just a post-conviction petition we're talking about. When we get down to it, we are talking about the fact that his trial counsel did not put on a known witness who could have rebutted the victim's statement and story about what happened in this case. That's a huge problem. And I know we're not here to talk about the merits of that case, but I think it's really important to understand what Mr. Paschel is going to be losing if this court affirms the trial court. The post-conviction court said that we had a comprehensive petition. It also, in its order, says that the verified affidavit was filed within an appropriate time frame. in accordance with the law. And yet still it dismissed the petition. The post-conviction court said we were reasonable and diligent in our efforts, prompt efforts by counsel, and he also said that the facts differ significantly here from what was in Maxwell. And that's where I get to why Maxwell is also not a jurisdictional issue, notwithstanding Hinton anyways. When we read all Maxwell and all of the other post-Maxwell cases, there is an element of dilatoriness in all of them. And all an element of dilatoriness completely different from what has happened in Mr. Paschel's case. Absolutely, markedly different.
And those cases, they talk, the courts, Fritz, Terry, I think maybe Vaughn too, they talk about what hadn't been happening in all those. But does the court ever say and use that as a legal basis to say, oh, okay, well, if you'd been more attentive to this, then we'd have a different ruling? It seemed to me like reading those that they're just saying, yeah, they haven't really done anything. They've just been ignoring this for several months, which is, as you say, the opposite of what you and Mr. Gaines had done in this case. But I don't read them to say that the dilatoriness of the person is the basis for finding that the jurisdiction's gone. They all seem like they come down to, well, here's what the statute says. To me, it doesn't matter whether or not the lawyer was dilatory. So can you speak to that a little bit? Why do you have a different conclusion than I do?
So for two reasons. One, the dilatoriness, if we look at the dissent in Maxwell back in this court, which is what the Supreme Court in Maxwell appears to primarily adopt and get its reasoning from, Judge Dyer remarks that this could have easily been corrected had they just done something sooner. And so I do think that that absolutely does speak to the fact that dilatoriness matters here. And secondly, I would go to Hinton and say that we kind of have the flip side there, and this is more thoroughly outlined in the reply brief we filed. But where we see that dilatoriness makes a difference there, and again, why this is not a jurisdictional issue, is because back in Hinton, the state did not say anything about it, and so there was never any notice to the petitioner that he needed to do anything else. And so it was the dilatoriness in that case of the state. So there is absolutely an element of dilatoriness versus diligence by counsel, petitioner, as to whether or not these petitions should be thrown out. In Maxwell, it was 50 days before anybody did anything. And it was the counsel in that case didn't file a verification until after the petition had already been thrown out. In Vaughn, there is no amended petition, there's no verification until at least a year later, a year after it's been put on notice. In Hinton, we don't get a verification until we get an oral verification at the hearing when it all comes to light. And in Fitz, one of the newer cases to this court, in Fitz, by my reading of that case, there's no verification actually until sometime this year after this court intervenes and tells counsel while in preparing for this that there's nothing in the record about that. We don't see the actual file-stamped version of that. So I think that what we have here is that dilatoriness versus diligence of trying to fix this issue and get that verification in absolutely makes a difference. And we have the absolute best case that this court will have seen yet, and that is in 6 days. We filed this on March 6th, sent it out to him to make sure. He had been collaborating by sending us his notes, so we were under the impression he would absolutely verify this. We sent it to him. I have sent it with a verification form letting him know to please get it to us as soon as possible. Friday happens, the weekend happens, Monday happens, and on Tuesday, the state files its motion to dismiss talking about this. It's in our affidavits in the record. I spent, I think it was 13 phone calls with the prison before I got to anybody who said, we'll try and go find Mr. Paschel so we can get this and get him on the phone for you. I heard 2 hours and I heard nothing back.
When were you all retained to represent him on the appeal?
I believe it was August, Your Honor. I said the same thing back in the trial court. I had said that that was a better question for Mr. Gaines. He had been primarily retained on this, and I was assisting him.
Y'all didn't try the case, you just handled the appeal?
Correct, Your Honor. And I should make sure I'm clear, too. Even though I was a law clerk for Mr. Gaines, during the time he and Mr. Witt represented Mr. Paschel on his direct appeal, I didn't actually work on that case. It was one of the very few ones that I did not work on during that time period.
So the petition was filed when?
The post-conviction petition, it was filed on March 6th, which would have been one day before the deadline.
Okay, so potentially the case was with your office from August to March before it was filed?
Correct, Your Honor.
Okay, I was just curious.
And there is a lot of, part of why Mr. Gaines is not here, there's obviously a lot of animosity in this case, and a lot of that is happening between Mr. Paschel and Mr. Gaines at this point. And a lot of that I'm not able to speak to directly. I wasn't as much part of the process. So as much as I'd like to answer.
The animosity is not with you, Mr. Gaines, but it's with Mr. Gaines and.
Correct, yes, not me, not between me and Mr. Gaines, but I'm here today to, you know.
I just wasn't sure what you might be
Yes, Your Honor.
referring to. Okay.
But again, that is why I see that there is this element of dilatoriness. The cases all allude to that. And it's very clear in the fact patterns just how delayed. And this gets to a lot in our reply brief about due process, which is that he has to be pursuing his rights diligently. And I believe that Mr. Paschel at all times has been trying to pursue his rights diligently. At all times, he has tried to get this thing done and get it fixed and do everything he can to get this post-conviction filed and get it heard, especially because of how serious of an issue. This isn't like some of the post-conviction petitions I've seen where we're kind of throwing spaghetti at the wall and hoping something sticks. This has a very serious allegation in it about that could have directly contradicted what the victim said by the victim's own account.
So are you arguing that the one-year statute should be told for that 12-day period of time that it took to get the verification, or are you saying that you got it in within the time frame?
I'm saying, I'm sorry, Your Honor.
Go ahead.
I'm saying both. I think that we fit due process tolling, but notwithstanding, I believe that that Maxwell just is not read to be this absolute rule and absolute procedural bar. There's a lot of reasons for that in the brief. I think one of the big ones, though, is going back to how Maxwell at the Supreme Court does interpret what the literal words of the statute are. And it really gets back to that 106 part where it says, well, only a pro se petitioner gets the opportunity to correct. Well, it doesn't quite say that. It's not about any deficiency. It's about whether when they don't provide any facts to the court, not a verification. It doesn't get to that. I think if we look at the literal language, and I know this starts teetering on trying to say Maxwell's wrong, which I'm not trying to get to with this court, but I think we can look at Maxwell to say, clearly the problem with Maxwell was saying we shouldn't read things into the statute that aren't there. That's the real principle of Maxwell. It was telling this court, you can't read something in there that's not there. I think awkwardly, it ends up doing that by the interpretation it has of 106. But notwithstanding that, the principle of Maxwell, and what it's been cited for by the Supreme Court, and I believe by at least this court in a dissent, is that we can't rewrite statutes here. And if we go and look at what is plainly in the Post-Conviction Procedures Act, even though it says you have to be verified, it doesn't say that you can dismiss it for just not being verified. It doesn't make that an issue. We need to have it verified.
Well, what's the remedy then if a petition is not verified, if it's not to dismiss it?
I think we have to come into, does anybody say anything about it and is anything done about it? And if we get all the way through a hearing and nobody's verified it or done anything about it, I think everybody might be too late. I think it's kind of one of those things where there's not really a remedy for it. I don't know of many post-conviction petitions, and I'm going to try not to get too much into my rebuttal time, but I'm not aware of many petitions, and even in my own case, and I can only think of one, where we don't actually have the petitioner testify, which would then equal out to being an oral verification, the same as in Hinton. Thank you.
May it please the court, Catherine Redding on behalf of the state. The post-conviction court properly dismissed the petition because it lacked jurisdiction. Post-conviction claims have a one-year statute of limitations, and the General Assembly has expressed a clear intention that it the filing deadline be construed as strictly as possible. The statute of limitations for filing a post-conviction petition is jurisdictional and is not an affirmative defense that has to be raised by the state. The Tennessee Supreme Court has said that post-conviction claims may be terminated for failure to comply with the procedural requirements of 40-30-104. 104D provides that in filing a petition for post-conviction relief, a petitioner shall include all claims known to the petitioner for granting post-conviction relief and shall verify under oath that all the claims are included. 104E makes it clear that the verification under oath requirement is mandatory, and it applies to both original petitions and to amended petitions. In 106D, the legislature clearly granted trial courts the limited authority to permit pro se petitioners to correct deficient petitions, both in terms of factual deficiencies and procedural deficiencies, such as a verification. But the Tennessee Supreme Court explicitly stated, it's not just an interpretation of Maxwell. The court said in Maxwell that the legislature did not give counsel the opportunity to correct these same deficiencies. And Judge Sword, to your point, Maxwell itself does not discuss, there's no requirement that analysis of counsel's behavior, whether it be dilatory or not, that is not part of the Maxwell analysis. Certainly that may have been discussed in the dissenting opinion from this court in Maxwell, but the Supreme Court's opinion in Maxwell stands alone. And maybe it did adopt, or it did side with the dissent in Maxwell, but if it wanted to read in an analysis of counsel's actions and whether counsel was dilatory and make that part of the analysis, it would have done so. And the fact that the dissent discussed that in Maxwell really has no bearing, because the Supreme Court's opinion is what controls, and if they chose not to examine the reason behind the failure to include the verification, that was a decision that they made, and we are bound by what is in the actual opinion. And I think to your point again about the dilatory nature, and the reason this comes up is because that is often why there's no verification, because counsel just was not on the ball. But the fact that those are the circumstances that have been presented doesn't make it part of the analysis. And certainly there are going to be situations where the verification just doesn't make it in, but counsel's behavior doesn't arise to the level of being dilatory. But if we look at what it controls, which is the Maxwell opinion from the Tennessee Supreme Court, that's just simply not part of the analysis. Here, the trial court lacked jurisdiction to consider the post-conviction petition. Counsel filed the petition on time, one day before the statute of limitations ran, but it was an incomplete petition because it did not include the petitioner's verification or signature. Because the petitioner filed that petition through counsel pursuant to Maxwell, the trial court had no authority to let him amend the petition. That is very clear under Maxwell. This rendered the petition a nullity, and it put the petitioner in the same position as he was before this petition was filed. Basically, he's in the position of having nothing on the record. So what petitioner could have done was filed a new petition through counsel that included a verification. He had until the statute of limitations ran to do that, which in this case, unfortunately, was only a day. But if he wanted to file it later, he could have filed a late petition, but then he would have to do so in reliance on some sort of tolling provision. But the petitioner did not file a new petition. He didn't file one within the statute of limitations. He didn't file a new petition later requesting tolling. So, and even if this court were to construe the verification in affidavits that were filed 6 days after the statute of limitations had passed, as a petition, a new petition, the petitioner simply would not be entitled to tolling of the statute of limitations. Simply put, none of the statutory tolling provisions apply, and while the petitioner claims in his reply brief that he is entitled to due process tolling, it is clear that none of the recognized due process tolling exceptions apply. He doesn't assert a new ground arose after the statute of limitations ran. He doesn't assert that he was mentally incompetent. And he doesn't even assert that his attorney's misconduct prevented him from his filing. He says his attorneys intended to file the verification, but this is not misconduct as we understand it from the case law that would toll the statute of limitations, because it is not counsel abandoning the petitioner, acting adverse to his interests, or actively lying or misleading him. Maxwell is binding precedent, which this court cannot overrule. And because the petitioner's unverified petition was a nullity pursuant to Maxwell. His late filings could not relate back to a nullity, and he did not file a new timely petition or a late petition where he asserted he was entitled to tolling. The trial court simply found properly that it lacked jurisdiction to consider his post-conviction claims. And I just point out, so if we look at Maxwell, what we have in that situation is a petitioner who files represented petitioner who files an unverified petition. Yes, the state filed a motion to dismiss and the petitioner didn't respond. And the trial court then dismissed the petition 50 days after the motion to dismiss was filed. But what we have in that case is a petitioner who files a motion to reconsider and amend where they provide a verification page that shows that the petitioner actually verified the petition before it was ever filed, 2 weeks before the original petition was filed. So if the Tennessee Supreme Court found in Maxwell that a petitioner that a trial court lacks jurisdiction to consider a petition when the petitioner has proof that it was in fact verified before it was filed, then certainly in a situation here where the verification is not signed until after the petition is filed, if that's not enough, if what's presented in Maxwell is not enough to give the trial court jurisdiction, then certainly what we have here is not enough. And as to Hinton, it's the state's position that respectfully, Hinton was wrongly decided because courts get their jurisdiction from either the Constitution or statute, and parties can't just agree to vest jurisdiction in a court when neither the Constitution nor the statutes provide that jurisdiction. You can't just say, we agree that you have jurisdiction. But even if this court were to say, no, we think that the situation in Hinton, that the facts were different. So we think that in that case, there was jurisdiction because of what the state did there. Then it's the state's position that this case is distinguishable because in Hinton, the state filed the motion to dismiss. Acknowledged that the petition met the threshold requirement and didn't say anything about the lack of verification until they were at the hearing. But whereas here, the petition was filed and within days, within a week, the state had filed a motion to dismiss, raising the issue of the verification. So this is not a situation where we get all the way to the hearing and all of a sudden, for the first time, the petitioner is probably after the statute of limitations is told and there's nothing to be done, where the petitioner is hearing for the first time, the state's position is this, the court lacks jurisdiction because you haven't verified. This was done much earlier on, and there was no agreement that the court had jurisdiction. So if this court declines to revisit Hinton, it should at least look at the facts and find that this case, the facts that are presented here, are distinguishable. But it is the state's position that Maxwell controls, and under Maxwell, the trial courts here just did not have jurisdiction to consider the post-conviction petition that was filed because of the lack of verification.
Can I ask you just a hypothetical situation?
Sure.
Just something I've thought about for a while. On the trial bench, I saw a lot of these. So let's say that Mr. Gaines sees that, March 7th is coming up really quick. I'm not going to be able to get this to you to verify. Here's what I need you to do, Geoffrey. I need you to take a piece of paper and write, I am seeking post-conviction relief because I received ineffective assistance of counsel. Please appoint an attorney to represent me. And gave that to the jailer for mailing on March 6th. Could it have then, Mr. Gaines and Ms. Bowling come along and then corrected it, and then they would have gotten within that statute because it was pro se, then it gets to be amended. Would that have been okay? Because I'm looking at this and thinking,
Sure.
Man, it's almost always better to have the person do it pro se, even if you know you're going to take over for them.
You'll give me a moment to look at the statute again.
And I know that's not what we're dealing with here. It's just I was curious about that.
Well, I think that would be my first response, is that those are the facts before the court. But I think that I don't know. I mean, the statute says if the petition was filed pro se, then the judge may enter an order. I guess it could come down to I mean, frankly, it could come down to the relationship between the petitioner and the attorneys, because
Yeah, they also supposed to put in there, has any attorney helped you prepare that?
Right.
You're supposed to put that in too, but I don't know what the remedy is on that.
But if that's all the defendant files, then there's nothing from which the judge could find a colorable claim, and he could go ahead and dismiss it right then.
Right.
right. But I suppose if a petitioner, if he says,
You don't have to, because you never deal with the issue of whether you have counsel or not. I mean,
You're supposed to give them 15 days to correct it.
no, no, you
If
don't have to. You can do that. You have the discretion to do that, but
Yes.
you don't have to do that.
Okay.
well,
I'm pretty sure that's, unless the statute's changed.
That's the
no.
statute.
and the statute says a bare allegation that a constitutional right has been violated and mere conclusions of law shall not be sufficient to warrant further proceedings. So I suppose it would have to be a pro se petition that actually goes into some detail. So it would be so case specific, and then whether the attorneys are actually retained, whether they actually represent the petitioner, whether he files it pro se, and then there's some sort of preliminary order finding a colorable claim and then appointing the attorney to
Well, and be honest, I mean, every prison in Tennessee has the form to fill out for post-conviction that has all the boxes to check, and then the little blocks where you can fill in whatever you want to, that gets sent to the court. And then, of course, the judge then has to look at it for preliminary order, see if there's a colorable claim and whether it's filed timely, and then appoint counsel.
Yes.
So, but, anyway, so,
I think that it would come back, it comes back to Maxwell, the Tennessee Supreme Court's opinion in Maxwell, where it says that the legislature is responsible, that they create the policy. So this is the policy that the legislature has chosen, public policy the legislature has chosen to act to draw a distinction between represented petitioners and pro se petitioners. And here, on the facts that we have here today, we have a petitioner who very clearly was represented at the time the petition was filed. And because of the distinction that the legislature has chosen to make, which Maxwell explicitly found, this petition was a nullity, and the trial court did not have jurisdiction to rule on it. There are no further questions. The state asks this court to affirm the judgment of the post-conviction court.
All right, Ms. Pulley?
I don't think I can answer Judge Sword's specific hypothetical, but what I will say in drawing on that, and something we have mentioned in the brief, is that while the communication with the prison is not the primary issue here, it certainly makes it much more difficult to have free communication at any time with our clients. And in doing so, it is almost as if they are functionally pro se in some instances. So to your hypothetical, again, we are getting at a point where if we can't get it to him and we can't get it from him, are they not just pro se by having to go and file it by themselves anyways?
let me ask you that. This is something that I guess I want to parse through this and look at it from the very foundation, okay? And you have to file a timely, statutorily adequate petition to give the court jurisdiction. Would you agree with that?
I agree it needs to be timely filed.
And a proper petition.
It should be a proper petition, but what's in our brief, though, is that based on what the statute says about when a filing is considered commenced, it can be incomplete and then thereafter.
If they're pro se, it can be incomplete.
Which brings us back to Maxwell and why going back to, I believe that literal interpretation of what is actually in the statute.
But the
is not
statute,
looked at.
doesn't the statute say that a petition for post-conviction relief shall, and sets out what it shall have, and one of the things it shall have is a verification?
It does say that. It also does not have a particular remedy for that.
Well, the remedy is to dismiss it. It's not adequate. The court doesn't have jurisdiction unless these boxes are checked. Isn't that what the statute indicates?
I respectfully disagree because there are specific reasons the statute enumerates as to when it should be dismissed. And although a failure to have a factual basis is a reason, the failure to verify it is not.
Well, now, as Judge Montgomery mentioned, when the trial court reviews a petition for its preliminary order, it can summarily dismiss it because it doesn't satisfy the statute. One of the things it can do is say, you just have a bunch of naked allegations here without any factual basis, therefore that's inadequate, I'm going to dismiss it. You can raise a bunch of claims that have been previously determined or waived, that can dismiss it. If it's not verified, you can dismiss it because it's not been properly filed before the court. All those are all remedies that are under the preliminary order.
I agree with all of those except for the one about verification that is noticeably missing from the statute as a reason to dismiss. And I would go also to the Supreme Court's own rules that it promulgates for the Post-Conviction Act, which is Rule 28. And if we look at 5E, it has 6 things that a petition shall have, one of those being an affidavit for verification. But when it promulgates its own remedies for what it shall do in relation to that, in 5F, it has only 5 reasons to dismiss, and noticeably missing from that list is failing to have that affidavit verifying the petition. And so I hear what you're saying, but I respectfully disagree with that because the plain language of the statute, we are very much into statutory construction, and it's obvious that the Supreme Court has decided to exclude the verification as a reason to dismiss, even though it says it has to have it. Which then I'd go back to Maxwell and go, okay, I don't think Maxwell is supposed to be a literal jurisdiction per se rule because the Supreme Court has promulgated its own Rule 28 and has specifically left out verifying the petition as a reason to dismiss. So I would say that, again, I get back to the principle of Maxwell was that we cannot expand statutes. And it's been cited for that proposition at least twice. And I would say that when we get down to it, if that is the principle of Maxwell, if we start reading into the statute a remedy for no verification when that remedy has specifically been left out, we are then just rewriting and expanding the statute, or narrowing it rather, when we're not supposed to, which is exactly what Maxwell says we can't do. I am running out of time, but as for due process, I really encourage the court to read our reply brief on that, especially as to due process as having been waived. I don't believe it has been waived. We've pled facts and the circumstances about it, and I believe we meet due process tolling for that reason. I believe that even though there are only certain recognized reasons for due process tolling, that it's not an exhaustive list, and that I think based on the full circumstances we have here, Mr. Paschel deserves due process tolling. If due process can make something like the actual statute of limitations flexible, certainly when we fix it in 6 days, that flexibility should be honored. Additionally, when the state has been up here saying, the petitioner says, and he says, I know that's what they say because we are usually one and the same, but I think it should be really clear to this court that Mr. Paschel is not saying these things. We are saying these things. We are the ones who have done these actions. We are, not him. And for due process, I think that because we filed timely, we had no reason to need to plead. If the court finds that we didn't plead due process enough, we had no reason at that time to plead due process. It was timely. So until the trial court dismissed it, we didn't know it was a nullity and that we would need due process tolling. And so now we've risen it here to this court, and so this court should have the facts in front of it to look at due process tolling. I believe I'm out of my time. I'm sorry for running over. We ask this court to reverse the trial court, remand this case back to the trial court, grant Mr. Paschel an evidentiary hearing on the merits of his petition that is comprehensive, clearly been fully investigated, and has the facts that are needed and that he would verify. Thank you, Your Honors.
All right. Thank you. Move forward.
I'm good either way. Yeah.
Go ahead. Let's call the next case then, Madam Clerk.